This podcast is brought to you by Independent Building Advice. IBA acknowledges traditional owners of the land and waters this podcast is recorded on. If you find this episode helpful, follow us for more so we can continue putting out free value for all homeowners in Australia. It really goes a long way. Enjoy the episode.
So when you go to buy a property, you need to know the legal side of it. Today we've actually got an expert with us. We've got Kealeigh Barker from Lavan, who is going to talk to us about titles, what to know, knowing what the law is behind that so you are protected. And we're going to get deep into this right now. Kealeigh, welcome aboard to the podcast.
Thanks for having me, Behan.
Awesome. Look, you're actually my go-to for a lot of, I don't know where to go for legal advice, so speak to you and you point me in the right direction. Lavan's obviously a great legal firm in Perth. Maybe give us a bit of your background for people listening and then we can get into the topic for today.
Yeah, so I've been a lawyer for quite some time. I was admitted as a lawyer in 2010 and I worked in a small firm for about 17 years. That gave me a lot of background information on a lot of different types of areas of law, and I had pretty extensive experience in a few different areas. So wills and estates, conveyancing, business settlements, lots of property law, commercial law, contract drafting, advice in many areas of business, from small business through to large business. So it's given me a lot of background information that really helps me with a lot of matters. Now, in the last year or so, I moved to Lavan. So being a big firm, things are quite different to what they are.
Good move. You happy with it?
Absolutely. I think my only regret is that I didn't do it sooner.
Yeah. I'm glad you said that because they might be listening.
Lavan's great. Big firms tend to do things a little bit differently. They generally, people who have worked in a big firm for their whole career are usually kind of pigeonholed into one area of law. And I'm really happy that the team that I'm in kind of lets me go a little bit outside of the strict property and leasing, which is, my department is property and leasing.
Yep.
So I'm still able to do things like share sale agreements and some of that more transactional side of things, while still getting a lot of more experience in the off-the-plan contracts, strata matters. I've always dealt with those things on a much smaller scale than what I'm doing now, but it's been really great.
Well, so it's such a big company, I'd imagine you get a really broad sense of inquiries or problems or issues. So something like that would be great exposure to new areas that you probably maybe sometimes unfamiliar territories or challenges your expertise and things like that.
Yeah, it's also great that I'm surrounded by a team of experts.
Yep.
So if I don't know, I know someone who does, and I can easily grab a partner or someone else from the firm and bounce ideas off them. If it's a complex or a niche matter, we can pass things on if we need to.
Yeah, imagine. I mean, I often come to you and say, hey, I know someone's got this problem. What do I do? And you give me some broad advice and then you'll say, yep, that's me. Or you'll go, no, this is someone else here that can help us the best person, which is great for you and also for the business, but also mainly for the client, saying it's a one-stop shop for the right legal advice, depending where it might be.
Yeah, and if the clients come through to me, I still like to kind of be involved in the process as well and make sure things are running smoothly and, get feedback where that's needed and make sure that client relationship's really looked after. It's something that's really important to me, is managing client expectations and managing the relationships with them as well.
Well, 100%. I think that's awesome you've got that mentality, but I think your greatest strength, and we've talked about this before, or you've told me many times before, but I agree with you, is that you can take something, I think it's called genius. I think there's a phrase around this, but you take something really complicated and you actually break it down to the layman who goes, okay, this is my problem, and you're very good at explaining it at a level that people can understand in plain English. I think that's really one of your best strengths. I know you've got lots of strengths, but just really getting that across, you go, I know what you mean, rather than all the technical terms or jargon. I think you're great at that, and I think your clients appreciate it.
Yeah, and that comes from my experience with the smaller businesses and mum and dad kind of investors. They're not generally sophisticated clients, and so they do need that little bit of extra help, which I'm happy to give. Obviously, Lavan is a little bit different now. Most of the clients are much more sophisticated, so I don't have to do that so often.
Yeah.
But I do still think that ability to translate that legal jargon into plain English is beneficial.
Yeah, absolutely. And we're trying to do that with building as well, because, again, you have people who just naturally say something off the cuff, and everyone knows it in the law firm, but they might not know it in real life. But we'll test you out in a minute and see how down to earth you can bring it down and to everyone's level. But talking about titles, I guess let's start with titles. So you've got green title, you've got survey strata, you've got build strata, you've got all these different titles out there. Most I'd say most people I encounter aren't aware of the differences. They might have heard of them, but don't really know what that means to them. Could you walk us through different titles, what they are?
Yeah, so I guess the main difference between a survey strata plan and a strata plan is that a strata plan is more like your built strata. It's apartments. The buildings show on the strata plan, and your land is delineated on the plan by showing the boundaries of your part of the building, whereas a survey strata plan is a parcel of land that's part of a strata plan, and your building doesn't necessarily show on the plans. Most of the time it wouldn't. The actual plans themselves will show the boundaries of your parcel of the land. So there's a bit more flexibility in terms of ownership rights and what you can do with your property on a survey strata plan. It's quasi-green title, but sometimes there's still common property. But the nature of the common property might just be a shared driveway. So like your battle axe blocks and those sorts of things. It can be a lot more complex in a in a strata scheme. A strata scheme might have things like pools and concierge desks and exclusive areas.
Ongoing fees sometimes.
Yeah, huge fees. Definitely a lot more fees in a strata plan than in a survey strata plan. So it's just a matter of finding what works. If you're going up, if you're going to do apartments, you pretty much it's going to be a strata plan. And like I said, survey strata plans are more your townhouses and your battle axe blocks and things like that.
And green title?
Green title means it's yours and your boundaries are your boundaries and you do what you want. There's no owners corporation, there's no strata levies. You just pay your normal rates. You insure your own property. You don't have to worry about sub meters and things like that.
Yeah. No, that's great. And just to put that, just to really make that basic. So, if you own your own block outright, and that's generally a green title one, people hear the word strata when it comes to survey strata. This is what we've found, and they go, "Oh no, I don't want strata. I don't want ongoing fees." Well, there's probably not ongoing fees. You might have, like you said, you subdivide a land. You own your land outright. Everything on that is in your control. You don't, with survey strata, you don't need permission from your neighbours because that's your land. It's as good as green title from resale from what I've seen. I think green title is probably slightly better than survey strata because for resale, is because people are more familiar with it. And then build strata, you're getting into other costs and so forth. And I think a lot of builders go, we want to build 2 or 3 at one time. Let's go build strata. But you can actually get around that, and you actually can do survey strata if that's better for you, depending on fees and that. That's a completely different subject. But you just got to. But I think they default to that where it might not necessarily be the best option for them.
And my understanding for a survey strata plan is the upfront costs are higher than what they are with a strata plan in terms of surveys and things like that.
A lot more expensive, yeah.
Yeah, so there are different considerations. I think what's important is if you're looking at subdividing your block or developing it, get advice. Ideally, get the advice before you sign the contract. I've had clients in the past who have signed a contract to build a development. They've got all their plans and designs sorted. They're going to build 4 survey strata plan units on a block of land. And then after settlement, they've realised there's an unregistered water corp easement. And it means that they have to set back their boundaries of the properties a little bit further, and they actually could only build 3 apartments or townhouses on the site. So, that would have been really good information for them to know before they'd signed the dotted line and settled on the property.
I couldn't agree with you more. It's great to get the information, but if someone's not aware of the legal part behind it, you've got like a settlement agent, then you've got like a finance broker, then you've got lawyers, and then you go, do you have to go get lawyers to get all their fees? Or when should you go to a settlement agent? When should you go to the finance broker, who's maybe know a lot about everything but may not be an expert? When you go to the legal team, such as you guys, where's the line there? Where should people decide which one?
Well, I should be saying you should always see a lawyer, but it's not always practical. And I think that seeing a lawyer for a basic settlement where it's just mum and dad's buying a house sometimes might be overkill, especially if the lawyers are charging more than a conveyancer. So it's worthwhile getting a quote to see what the difference is. Using a lawyer, I guess you could treat it a bit like an insurance policy, paying that little bit extra because the standard of care is somewhat a little bit higher, but also their obligations to you are a little bit different. I know my experience working in conveyancing for a law firm is that from the second you get a contract, you've got obligations to your client. And not to say all settlement agents do this, but I have heard of some where they don't even look at the contract until it's unconditional. So they basically lodge it for a stamp duty assessment and then do nothing else.
Yep.
So, there's definitely, you can have good and bad lawyers, you can have good and bad conveyancers, but I think that seeing a lawyer, especially if you're looking at doing things like subdividing, you want planning advice, there's due diligence involved in your contract and you want them to assist you with it, it's definitely the way to go. Some people see it as a cost-benefit analysis. It comes down to how much risk there is in the transaction and how much risk you're willing to accept. I think getting advice from a lawyer before signing the contract is a really great idea.
Yeah,
Over East, it's something that they require, but it's just not something we do in WA. And you're buying a $500,000 to $1 million property. So, that's first homeowners. So they need to really understand what they're signing and what the implications are. And if it costs you a couple of $1,000s to get some advice, and a straightforward O&A, it wouldn't cost that much.
It's 1% of the total thing or whichever, yeah.
So to get the proper advice and make sure, have you got the names on the contract right?
Yeah.
Do you want to add your partner on? Are there foreign buyer considerations where you might not want your partner on the title? You're going to have to pay extra duty. Are you going to use a trust? Because if you put it in your name and then want to change to a trust, you're going to pay stamp duty all over again. So there are some ways that you can avoid duty by drafting it properly. And there are some exemptions and different applications you can make, so substituted buyer applications and things like that. But it is really important to get it right. And
what's the substituted buyer's application?
So if I was to buy a property and decide before settlement I need my husband to be a co-borrower, otherwise I can't afford the property, you can add certain people that fall within certain classes of related persons onto the title, usually mums and dads, spouses, children.
Yep.
It means then that you can settle on the contract with the two names on the title, but once you've settled, making that change is not going to be as cheap or as easy.
Well, you cop stamp duty, don't you, if you're adding another person to the title?
Yeah, there are some small exceptions. So if you get married and you want to add your spouse onto your primary residence 2 years after you've been living there together as your primary residence, then you can do that. So you have to have lived in it as your primary residence for 2 years or be together for 2 years for it to be registered.
Is there a limit of how many spouses you can have do that with? Like, could you get married and divorced like 10 times and just keep adding?
Well, you could get married and add the first person on and then get married again and live in that house for 2 years and add the next person on. But nobody wants that many relationships.
Good to see big is not a big thing. Yeah, well, that's the thing though, is that what you just said then is, look, we say to everybody, you want to do a feasibility whenever you're doing a development or subdivision or something like that and work out all the hidden costs. It's so easy to get caught and not allow all the right figures, holding costs, stamp duty, legal fees, these kind of things, to only find out later that you haven't calculated it properly, and then you get stung, and then all of a sudden this development is actually losing your money, or you have to make a whole lot more money with that property to make it work. Is dangerous. So why not spend a little bit of money to get the result you want?
But even for mum and dad buyers, doing the inspections, getting the reports done, building inspection, is your roof going to leak? There's things. I had a friend who purchased a property where the seller had painted over some dodgy ceilings to hide the fact that it had been leaking, and she didn't get a property inspection report, and now she's facing having to pay the cost to repair the roof space. It's sometimes it's a large investment. It's your insurance policy. Do that little bit of a
due diligence. Yeah, absolutely, and make it happen. So on that, when you're doing a subdivision, what are some of the hidden costs that are involved? So let's say you're subdividing a rear block, or you're in, let's say, 3. What are some of the costs that people should consider with their subdivision?
So in terms of the costs of advice that you might need.
Yep.
It's about getting planning advice and legal advice and all those sorts of things. Other costs are going to be survey costs. So you need to get a surveyor. They need to do their drawings. They need to lodge everything at Landgate. In terms of the development itself, building costs, you'll be familiar with how they can blow out sometimes.
Maybe just a little bit, yeah.
Holding costs, interest rates on your loans. The longer the development takes, the more it actually costs you. So you've got to make sure that you get a proper feasibility study done. Part of that might be your due diligence. So have you got Heritage Act considerations? Are there Aboriginal Act considerations that you have to, consider?
Stamp duty, obviously, and things like
that. Stamp duty. I mean, everyone knows about stamp duty. So I think stamp duty and Landgate fees and things like that usually are not going to be something that people are surprised about.
You're amazed at how often, I didn't allow for that. Oh, okay.
Foreign buyer transfer duty would be a big surprise if that got triggered, or double stamp duty because you've done something that you shouldn't have and it's triggered the double stamp duty. Trying to terminate a contract to avoid duty and re-sign a new one, they'll catch you out.
Yep.
Claiming first homeowners grants and then not actually living in the property, and OSR will come chasing you to repay that.
So on that, I had someone I heard a while ago that when they were young, I don't know if it's true or not, when they were young, their parents put them on a title for whatever reason, had no idea about it. 20 years later, tried to claim the first homeowners grant and they got pinged on it, and that was a real issue for them. Is that a real thing, or is that?
Yeah, absolutely. There are some fairly new changes that have allowed some first homeowners to buy an investment property they haven't lived in and then subsequently claim the first homeowners grant, but you still can only claim once.
Yeah, we do that all the time, by the way,
And if one partner has already claimed the first homeowners grant and then, you go and buy a new house together, the second partner can't claim.
Yes. Does that, I'm putting you on the spot here, I was curious, does that happen when you're de facto? Because obviously de facto laws kick in when you might not be married, you might be living together, and then it's very similar to marriage in a lot of ways. Does that, if you're a de facto, do you know off the top of your head if that's, if one of you got the first homeowners grant that you can't do that, or is that mainly just marriage?
It's all about who's going on the title.
Okay, gotcha. Yeah,
so if one of the title owners previously claimed it, you wouldn't be able to claim it.
That makes sense. Yeah, no, gotcha, absolutely. And then, okay, so a settlement agent, and this is probably more of a statement rather than a question, but I find that if you go to a settlement agent and you're doing a standard transaction, let's say you're buying a house, termite, finance, whatever might be your normal clauses, and then you settle, most of the time it's probably going to be straightforward. What I find is the true value of a settlement agent is not realised until you have a problem. And I've had a few problems in the past with whatever it might be, people not having their finances ready or they're not meeting a clause. And that's where I figure, and I know settlement agents out there that can go, well, where our model is just volume. We're going to be the cheapest, and we're going to do volume because we're just going to try and get the numbers there. But they're not set up when things go pear-shaped or it's a bit tricky. And I think that if you're unsure, I think settlement agents, people go, it's just another cost. I think if you're unsure, I think getting that legal advice just to cover yourself. Ideally, you don't need the expertise, but if it's there at your fingertips, that's when it's really going to help you.
Yeah, and I think the thing with settlement agents is the second something curly happens, they just tell you to go get legal advice anyway.
Yeah.
Whereas if a lawyer was handling your file for you, depending on the way they scope their fees, they might be able to answer that question off the cuff. They already know the file. They're not necessarily going to charge you any extra to answer those quick questions, but that depends on the firm that you're with.
Be safe, but it depends obviously what you're buying. If it's just a block of land, who knows?
But it also makes a difference who the real estate agent is and how good they are at drafting their contracts. And believe me, I've seen some shonky contracts over the years.
Yeah, I can imagine, Because the actual proper terminology, isn't it?
Yeah, well, it's just, I think every time you're drafting a contract condition, it's really important to show the who, what, when, where, why, and how.
Yep.
Who has to do it and what are they doing and when do they have to do it by? What happens if they don't do it on time?
I think that's the big one that gets forgotten is what's the outcome if it doesn't?
Yeah, consequences. Can someone terminate? Who has the right to terminate? So it's really about getting those contracts drafted properly. And that's not just for land contracts. That's for every kind of contract. You really have to be clear.
Well, we're lucky we don't have gazumping here in WA, where over east you could actually go in there, you put an offer in, it's unconditional, but someone can come in and offer a better offer and they can just take over your O&A and they can actually win the property. Have you heard of that before over east?
The only way I've heard of that in WA is with some of the off-the-plan contracts. A developer can terminate the contract if they want to accept bulk offers from someone else.
Okay.
So if you were to walk into a developer and say, I want to buy all of level 5, and I will only buy them if I can buy all of those units on the same level, then they might go back to someone else who already has a contract on level 5 and say, hey, can we terminate or move you to a different lot within the building?
Roger,
I haven't actually seen anyone rely on that yet, but it's definitely in the contract.
I think in your general terms and conditions on an O&A, it says it's valid for 6 months as well. I think we had an issue, this is to go back 15 years ago, where if it hasn't settled in that time frame, that either party can pull out. And the reason why that was relevant was we actually had this land that had a long 12-month title. and it kept getting extended. All these people just sitting there, and then they're all going to get a big price rise from the builder because they'd all signed up. And I think we looked into it. There was a way that's gone too long. Either party can sort of pull out.
Yeah, if that's a subject to title clause, the joint forms do have a deadline for when you have to have titles issued by.
Yeah.
Off the plan contracts vary that.
Of course, yeah.
Sometimes out to 3 or 4 years, and then some depending on the size of the development. But generally anything else, if a settlement it hasn't happened on time, parties can issue a default notice and then terminate the contract and claim the deposit if they're not the party that's at fault.
Yes, absolutely. You got to find terms and conditions. You got to read them and make sure you're protected, but also making the advantage of it. Tenants in common and joint tenants, what are the differences with that on an offer and acceptance? And what are they and how does it affect people?
Yeah, so joint tenants is when survivorship applies. So it doesn't matter how many joint tenants you have on the property. Whenever they die, it automatically goes back to whoever's left on the title. It's most commonly used in husband and wife spouse purchases, so they know that when the first of them has died, that's going to automatically vest in the surviving spouse. No probate is needed. There's nothing really that can unravel that. The loan vests in the surviving spouse and the property vests in the surviving spouse. Great for some asset protection. I think we've done some great for estate planning. We've done some deals over the years where a parent wants to gift a property to a child and they want to give them the whole of the property, but that obviously attracts stamp duty on the whole value of the property.
So if you're passing it across, you pay the stamp duty.
Yeah. Yep. So we've done some shifty little deals where we have only transferred half the property, paid half stamp duty on half the value, and done it as joint tenants. So when the parent dies, it automatically vests in the child and avoids their estate. So it avoids claims from other
shifty
children.
But legal.
Absolutely legal.
Yeah, absolutely. Well, actually, on that, I do know the answers to a lot of these questions, and some of them I don't. But I've had people in the past go, "Oh, well, we're going to sell it to our kids for $1. Therefore, we'll only have to pay stamp duty on the $1." But obviously, that doesn't work.
No, you pay stamp duty on the full value of the property.
Yeah.
Yeah. There are some exceptions. So obviously you can gift it under your will and there's no stamp duty on that. Like I said before, you can do little things where you're only transferring part of the property depending on what it is you're trying to achieve.
Yeah.
You see titles sometimes where someone owns 1/100th share of the property and it's been done for borrowing purposes, like a token gesture that person owns a small part of the property. But
the reality, and just for people at home, what they do is they then get a third party valuer to value your property and say, well, it's not worth $1, it's worth $2 million. Guess what? That's what we're going to charge you at for 70.
Yeah, and if the children were taking over a mortgage that was worth more than the property, they actually would pay duty on that higher amount as well.
Well, there you go. Well, there you go. There's the government wins in the end. Basically, it's basically how it works. So you got and with that, with joint tenant and tenants in common, the simple way I look at that is joint tenants is that you both own it collectively, and then tenants in common is that you're completely separate parties and you both own your portion of the other thing in a very layman sort of way because, again, it's all, some of this stuff goes over people's head because it's completely foreign to them. Yeah. But and I guess there's probably time for that disclaimer that we talked about earlier, was that this is just general chat here today, and anyone listening, you got to seek your own legal advice for your own specific areas. I mean, Kealeigh, you're obviously awesome at this, but to talk to you, you will then explain it to people in the level that's best for them. Whereas we're just having a chit chat about different legal things you can do, which is great from that perspective.
Yeah. So with the tenants in common side of things as well, there's usually extra considerations for your estate planning. So
actually, what is estate planning? Walk us through estate planning for people.
Estate planning is getting your will done, getting your enduring power of attorney, enduring power of guardianship, advanced health directives. Sometimes it might be a binding financial agreement, so a prenup, making sure that certain things happen on certain events. A prenup generally deals with separation, but, there's those sorts of things, kind of doomsday prepping. If something goes wrong, what's going to happen to my assets? Yep. So in the tenants in common situation, you would need to get probate when someone dies, unlike the survivorship side of things where you don't need to get probate. The tenants in common as well, if you've got spouses, and usually this happens when you're in like a second marriage or second relationship, and you say, I've got my share of the property for me, you've got your share for you. When I die, it goes to my kids. When you die, it goes to your kids. But with that, you might consider things like life tenancies and rights to reside. So if I die, I don't expect you to sell the house or have to leave or anything like that. It makes it clear that my intention is you can live there for as long as you like, subject to certain conditions, which might be pay the rates and taxes, maintain the property, but you can't dispose of the property without making sure that my beneficiaries have been looked after.
Yeah, gotcha. Okay, yeah, well, that's cool. I know you did wills and that for a while there. Have you had any crazy requirements that, I don't know if you read the movie Brewster's Millions, where you're going to get 300 million, but you have to spend $30 million in 30 days to get the 300 million. But if you don't, you get nothing. But if you do, you win. Have you had any crazy things where people put in their will that
Nothing that crazy.
But people do ask them.
I do have people who say they want to leave something to the dog, but they have to be told that the dog is a thing. It's not a person. As much as you love your fur babies, the law does not recognise them that way. No. Generally, we would put clauses in that might say something like, Bob's going to look after my dog and I'm going to give Bob $10,000 for the feeding and looking after the dog and things like that.
Gold-plated chain and collar or something like that. But it doesn't really work very well, does it? Yeah.
But it's actually outlawed, some of those sorts of conditions. So there's very limited conditions you can put on inheritances. But what you can do is tie it up in a testamentary trust and get someone else to look after the money, and then you can have some control over what the children get and when. Yeah,
when they hit 21, they get the money, but at this point, until that point, give a 6-year-old $5 million, they may not be the wisest person to work with it. So, I guess it's interesting. But I guess you have to guide people as best as possible, and depending what state they're at and what they're going to say in their will, it's up to them, I guess, from that point of view. So, what are some of the rules that people may not be familiar with buying property? Like the grace period with settlements, things like that, because I find a lot of people aren't aware of some things that you and I might see as common knowledge, but just some of the rules around how that works for people out there that may not be aware of it.
Yeah, so the joint forms has a 3-day grace period in it. So off the plan contracts will contract out of that. Where you're buying vacant land off a developer, you'll probably find they'll remove that condition as well. So it's not always a given. But a 3-day grace period basically means that no one's going to charge penalties provided you settle within that 3 days grace. There's also in the joint forms a condition that extends that up to 5 business days if you're going from a PEXA settlement to a paper settlement. So it allows people the time they need to get forms prepared and exchanged in paper, because that's a little bit more difficult than logging in and settling electronically. There are timeframes for defaults and terminations. So, if you haven't paid your deposit on time, you have to have a written notice requiring you to pay your deposit within 2 business days, 48 hours. There are requirements to give someone 10 business days to remedy a default if they're in default under a contract. And then if they haven't remedied the default, you can then terminate the contract. If you issue a deposit holder's notice, the parties have certain periods of time to serve notices and respond before the deposit is just automatically released.
Yep.
So those sorts of protections are in there, those timeframes.
Yeah, and I guess it goes for both parties, but also if you're selling the property, it's really important, because you hear it a lot, actually, especially in this market, is that people sell a property and then out of the woodwork, someone 2 days later when they sign this thing, go, I'll offer you $300,000 more for that property. And they go, how do I get out? Well, you can't. It's actually, it might have conditions, but this is a locked-in contract. So you want to watch those conditions pretty carefully, because if you're 1 day over one of the conditions, you might have a chance to pull out. But if you were 1 day over, let's say finance is due and you're 1 day over, is that null and void now if it's not given an extension?
No, most contract conditions don't have an automatic termination clause in them, and it's something you would usually kind of advise against. Automatic termination clause just means it's dead in the water. You're going to have to re-sign, and you can't really, even though people do variations to bring it back to life, it's not really the done way. Yep. Once it's gone, it's gone. Finance clauses generally say that once that date has passed, the seller has the right to terminate.
Gotcha.
So doesn't mean they will terminate. There's no automatic termination. It does mean that if you're coming close to your finance due date or any condition due date and you're not going to meet those conditions, you need to get a variation done. We find sometimes clients want to do pest or building inspections and the seller's being a bit of a pain and not giving them access to the property in a timely manner, and dates are getting quite close, and then you have a bit of an argument on your hands about, well, it might have been due on Friday, but we've been trying to get access for a week and you've been unreasonable. We're going to have to extend that, and that's when you need your lawyers involved.
Yeah, and that's a great area I've experienced before, where that and it's never going to happen to me. But if you've gone the cheaper option being a settlement agent and you go, settlement agents, they just transfer paperwork, really. That's all they really do. And that stuff goes pear-shaped, where you're buying a property and they're disputing whether they should actually have to fix it or not fix it. And I'll give you a real example. We had one the other day where a client of ours actually got an inspection done, and the inspection said that something was a structural item and they had to fix it. They only had a few days to fix it, and it was a couple of grand. And then I ran it past the building inspectors that we use, and they said, actually, no, it's not a structural item. It doesn't actually have to be fixed. But it had this grey area. And then in the end, the client said, I'll just fix it. So the person selling it said, I'll just fix it because it's just easier that way because I want a settlement to go through. But it's that grey area. So, and then it's like, well, whose advice do we get? And that's where, luckily, we were in a position to do it, but we're not lawyers. And that's where you need that really good representation to go, this is what you can or have to do on that.
Yeah, I have seen some dodgy reports where the inspector is trying to say that something's structural and it's not structural. And the contract gives you a really clear definition. Generally, even the standard REWA forms say what constitutes a structural defect and what parts of the property are relevant. So sheds and outbuildings and sometimes pergolas and things like that, if they don't fall under the main structure of the property, they're not included in the structural inspection report anyway. I try to push people to use just a standard due diligence clause. If you're not happy for any reason, it doesn't matter that it's not structural. It doesn't matter that the termites are not live pests. If you don't like the look of it and it's not worth the money that you were going to pay for the property, it gives you the chance to pull out.
Yeah, well, that's actually a really good point. So one thing I recommend to a lot of clients at the moment is that we have it all the time. They see a property they love. Let me think about it. Gone. I like this property here. I just want to get someone to go through it and have a look at it. Gone. And then because they get snapped up so quickly at the moment because there's supply and demand. What we recommend to people is buy the property if you really like it and put in a due diligence clause, even 3 days a week, whatever, for me to come out there and look at it and say, okay, to renovate this home, it's going to be roughly this, or to demolish and build this home, you're looking at this, or this is a good property. That way you've locked it in. You've got to get out of free jail clause in there, being the due diligence, and we have a chance to look at it rather than come see us, we come through 3 days later and it's already sold and on to the next one. So I think due diligence is a great clause in there if you're not sure. Unfortunately with that though is that the real estate agent's looking for the best deal for their client or for themselves, depending on what they do. So they may knock that back, but to me I reckon it's a great way to go.
Yeah, even larger developments and bigger purchases, the due diligence clause is really important. You can have an option agreement that has a due diligence clause in it that says, I've got this period of time to make whatever inquiries I want. Might include development applications, lots of planning approvals or change of use approvals and things like that. It gives you the time you need to actually do what you need to do. An option would mean whatever option fee you've paid, that money is lost if you don't proceed, and it's a dutiable document, but
it's a what document?
Dutiable, so you pay stamp duty on an option agreement, but when you proceed to a formal contract, that stamp duty is credited off the final contract.
Yeah.
Usually used when it's a long-term, a very big development, there's lots of money involved and parties just want to get something documented quickly so they know what's important to argue about later. Gives them the ability to negotiate on purchase prices and things like that too.
Yeah, I think we did that a while ago with a land development. I think it was in Careen where the land actual sale date kept getting pushed back, and they had all these people that really wanted to buy it, and they said, look, put an option in there to buy it today. It's just a piece of paper, and then that, I think it was something like that where it wasn't. And then at the time when it got released, then you had first choice, and they put them in preference order, but you had to pay a deposit to make sure you're serious.
Yeah, it might have been a reservation form.
Yeah, something like that.
And that's something popular for off the plan developments as well. They still haven't got all their surveys done and all the information right, but they've got a concept.
Yeah.
So do people want to buy into that concept? And they can reserve certain apartments and pay that fee.
Yeah, absolutely. All right, so changing subject here. So scheme bylaws, considerations. This is for obviously build stratas, this kind of thing. Tell us more about that. What's involved in that?
Yeah, so I think if you're buying a strata property, it's really important that you review those bylaws. Sometimes there's some rules there that really will change the way that you can use your property. They might limit things like short-term holiday stay, which, you might be intending on using your apartment as an Airbnb and then you buy it and find out you can't. But it's also things like pets. Can you have a pet at all? Some schemes don't allow pets. If you're moving in and you've got an emotional support animal or a guide dog or something like that, then you might still be allowed to take that animal in if they're registered. But otherwise, there's no guarantee that your pets can come in with you. I've had clients who have been in Strata Schemes and they've had to take on their daughter's dog because she was unwell or whatever her situation was. And, they're getting notices from the Strata company. Like, dog's got to go. Either they had too many dogs or, there wasn't allowed dogs at all. So it is really important. You can't hang your washing on the balcony in a lot of schemes.
Wow. Yeah.
Because it's all about the aesthetics. From the street, they want it to look like a nice building.
Yeah.
There are some schemes that have great bylaws and some that don't have very good bylaws at all. And you'll generally find the older schemes need a bit of love when it comes to their bylaw updates.
How hard is it to change the bylaws?
It's not difficult. It does require meetings of the Council of Owners. They have to table these new bylaws and get everyone to vote on them. And then depending on the type of bylaw will depend on what kind of vote it needs. And then it's just a matter of instructing lawyers to draft them to go to the meeting. And then once they're approved, getting them to consolidate their bylaws.
Do you need a unanimous?
If there is Schedule 1 governance bylaw, it's unanimous. It's a special resolution without dissent, a resolution without dissent. If it's a Schedule 2 conduct bylaw, it's a special resolution or a general resolution.
Yeah, very different from ab on dissent. Just made it clear for people at home. Yeah.
So the reason,
Sorry.
A consolidation process is pretty straightforward.
Yeah.
It used to be when you ordered the strata plan, when you were buying a lot, all the different variations of the strata bylaws are all shown as separate documents.
Yeah.
Now they're required whenever they do their next update to consolidate them, so that it's one document you have to order.
Yeah.
I did a settlement for a scheme where they had a whole chain of documents, and it cost a few $100s to get all these chains of documents to try and figure out what the bylaws were and how they've changed along the way, whereas now you just get, this is the current set of bylaws.
Gotcha.
So Lavan can assist with that. We've got a great team in the Strata team that do all the consolidations.
Like, where do you start? And you go, well, this is a great start.
Yeah, well, I've just had a client query in the last couple of weeks where they said, we've got this massive set of bylaws. It's confusing. Is there anything we can do to review it and water it down? They'd already flagged that they needed some different bylaws put in there, things like cost recovery bylaws. So if an owner in a strata scheme has not been paying their levies or defaulted, does the scheme as a whole have to share the legal costs to pursue this person?
Oh, wow.
Or is there a bylaw that allows you to say the person that's at fault has to cover all of the legal costs?
Yeah.
Things
like
like
forward planning there.
Yeah. I've been involved in a strata AGM where they were trying to pass a bylaw to pass those costs on to a particular person, and that person wasn't financial at the time, so couldn't vote, but other members who were friends with them dissented. They wouldn't allow the vote to pass because they didn't want their friend to have to cop these fees.
Oh, really?
But at the end of the day, they were paying a share of them anyway. It was actually coming out their own pocket. It was crazy for them not to vote and allow the bylaw to go through. Even I think the same scheme had an area that they designated was exclusive use for 3 units. It was like an alleyway or just a shared common area that only those 3 units could access. So they were going to pass a bylaw to say those 3 units insure and pay for and maintain, cover all the costs for that shared use.
Makes sense.
They wouldn't pass it.
Is that just people being stubborn?
Yeah.
No, the law is what the law is.
And that's the difficulty with strata. It's like politics.
Oh, absolutely.
Everyone has an opinion, and sometimes that's great, and sometimes some schemes are run really well. They've got great strata managers, and other schemes is just people who just don't want to budge.
Yep.
I've had a scheme, it was an older scheme, and had a client query from an older gentleman who didn't want the youngies to have EV chargers.
Oh, really?
Yeah, he's like, no, it's not something that I have to worry about. So, as a scheme, it's not something we're going to approve. Yeah. We don't want these, we don't want these chargers in our scheme. I've had other schemes where they want EV chargers, but they can't do it because the scheme itself and its all of its infrastructure, it just can't handle it. Yeah. So then they go, well, we need to update it. But to update it, they have to get every owner to fill in forms and consent and provide synergy account details so they can actually transfer and get everything updated and do something called an embedded network.
Yeah.
And they can't get all the approvals they need.
Well, yeah, if you're overseas travelling and you're not checking your email, well, bad luck, you can't do anything about it.
Yeah, or you've got tenants and you need the information from the tenants because it's their electricity account.
Ah, yeah, okay, yeah.
We've got another one. It's a re-subdivision of a a scheme, and there are so many consents involved that by the time we actually get all of the consents needed to lodge the re-subdivision, other people within the scheme have sold their lots.
Yeah.
So there's different people that have to consent and different banks that have to consent. Yeah. So it's just this thing, it's just everything just keeps moving. So sometimes
problem after problem. Yeah.
Strata can be very complicated and complex sometimes.
Yeah, well, we've had I was at a meeting today. We're looking at renovating a front unit. And the lady that I met with was looking at either selling that unit and buying somewhere else or renovating. I said, well, actually, it's a big unit. We can actually do this or this and this, move this around. But no matter what we did, it was still a little bit small for living areas. So we could just extend this room. And we're talking about 2 metres. That would be a decent sized room. But it's in a survey strata. So it's in a strata plan, and she's got to get permission from the 3 other houses. Luckily, she gets on well with them. But you just need one of them to say no, because just for people at home, you can't change anything external in it. You can repaint a room internally, but anything external, you have to get permission from everybody. And this is luckily she's with only 3 other units, so she's the first one. But still, if you're in a big one, you've got a lot of people that you got to get approval from. And I find that people, if they don't understand it, they'll generally say no, and they go, it's too hard, no. As opposed to hence why if we need permission from neighbours, I'll catch up with them face to face, explain it to them. You're better likely to get a yes, because if they can't read a plan, they say no. And I think that's the risk you've got of being in one of those areas.
Yeah.
Yeah. But we also had another one where we had there was 3 in that strata plan, and we actually changed it to a survey strata. Cost a bit of money to do it, but the clients wanted that, and they spoke to all the other people in there, and they all agreed to it. So that we went through that cost thing for them, but it was a better outcome. They could do whatever they wanted.
Yeah, there are some smaller scheme exemptions as well. So 2-lot stratas basically don't have to comply with anything really in the Act at all. And then you've got like a middle ground where it's 3 to 6 or 3 to 7 lot schemes. There's certain things they can contract out of depending on the size of the scheme. So things like having a letterbox for the scheme, making sure that, there's levies collected and AGMs are held and things like that. Generally, an AGM has to be held for every scheme, but it can be as simple as, the few owners getting together and having a coffee and talking about the strata insurance they're going to renew.
Yep.
We've dealt with schemes that are not compliant. So you have the same owner who owns a whole load of apartments in one scheme, and they just let it all fall by the wayside. They don't worry about strata levies. They just rent everything out. So it really just depends on how they want to run it. It's only a problem if one of the owners kind of kicks up a stink and goes to SAT, or they have to go and get legal advice.
Well, you see those people in America where they got like the home HMO or whatever they're called, like, and they walk down the street and you haven't weeded your garden enough, and they have a crack at them. I'm sure some of them will probably be a bit like that in Perth, where you've got one person that's a bit militant and tells everyone else what to do.
There are a couple of estates that have homeowners associations. They put caveats on their titles, and they pay a levy that goes towards running something from the scheme. It might be things like, security checks every now and then, those sorts of things.
I got a few neighbours I would love that. Oh, power. Kealeigh, look, thank you so much for coming on. You are a wealth of knowledge. We'd love to get you back on in the future to talk more law talking jargon sort of thing, but it's great. But the thing is, though, that what I found with so many people is what you think and what you assume is the law or what's right is often wrong. You said something to me a couple of weeks ago, which I thought was great, is be super careful with getting legal advice from AI. Maybe you could talk a little bit more on that, because when you said that, in fact, you didn't say it, someone else said it, but you told them to say it. I went, oh my God, you're right. And I did see a lawyer a while ago, and I ChatGPT'd all this information. So I know what's this. And he goes, no, it's completely wrong. Talk to us a little bit about that with AI and that, just a fraction on that, because it's important.
It's funny, just in the last couple of weeks, I've had emails from clients who are telling me the legal advice they got from AI, or the bylaws that were drafted by AI, that just are completely wrong. One was about method of executing documents, and another one was drafting some simple bylaws that said there was going to be no strata council, which is one of the things you can't contract out of under the Act, under the Strata Titles Act. So there are lawyers who have got in a heap of trouble for using AI to do their court pleadings.
Yeah, wow.
Getting told off by the court. AI has its place. I love AI. I was drafting a contract today, and I would draft a contract condition, which was okay, and then you just run it through the AI and say, fix this. it allows us to do things faster, which clients would love when you're doing work for them on an hourly rate. It means that things are done right. We have an AI add-in at work that does things like checks your cross-referencing and your definitions and your finishing touches to your documents.
Yeah. It's got its place.
Yeah, absolutely.
But when you're messing with the law,
to give legal advice, I would say use it carefully.
Yeah.
It all comes down to the prompt and the information that you're giving it. It comes down to the quality of the AI that you're using. But yeah, it's like with anything. You just have to take it with a pinch of salt.
Yep.
It's great for giving you a quick piece of information. If you want to know what your land gate fees are, or where to find a section of the Strata Titles Act, or how does this affect me? If you give it enough information, generally it can give you something that's worth using. And it's getting better. It's scary how far it's progressed, even just in the last couple of months with the programs I've been using. You've gone from it generating documents you can't open and text goes off the page and it's not even usable, to now drafting and formatting. I'm very good at seeing what's been created, with being able to tell what's AI generated.
Yeah.
There's certain phrases it uses and certain formats it uses that are a little bit unusual.
Yeah.
So, when we got the bylaws that a client drafted, and I looked at them, I said that they look like they're AI drafted,
Well, the end dash, I think it's called, gets you. It loves a good end dash.
I think it's great for a starting point.
Yep.
Don't rely on it. Always rely on proper advice. And also bear in mind, if you get advice from a lawyer, if they're wrong, they've got insurance.
Yeah, that's a good point.
It's an insurance policy in itself. Yeah. Get a lawyer to look at something.
Absolutely. Well, plot twist, I am completely AI generated. I'm not actually a real person. Oh, actually, I am. No, all right, so we've got a closing tradition with this podcast, and we ask everybody the same question. And I know we've given you a heads up beforehand. No, we haven't actually this one time. So the question is, so you're building or renovating your own home, extending it, whichever. You're about to pull the trigger on it. Then all of a sudden you get a letter. Someone's done their proper will properly, by the way, here. And they said, Kealeigh, here's $10,000 check. You have to spend it on your house and something cool. What would you spend it on?
What would I spend it on right now?
What would you spend it on, you personally?
Well, I've built a house and been in it for a couple of years, and we are hanging out to get our outdoor kitchen done.
Good choice.
Outdoor kitchen, bit of artwork around the house, a few little finishing touches. Yeah.
So pick one. You can't have. Outdoor kitchen.
Well, the outdoor kitchen's only $12,000, so I've got money left.
There you go. Well, it's $10,000. So if that's $12,000, you get $2,000.
Sorry, not $20,000.
But you negotiate well.
Yeah.
You have money left. I'm sure.
I'm sure you know a guy.
Yeah, I'm sure I'll be able to help you out. I know someone maybe. No, but look, at the end of the day, that's great. Outdoor kitchens, beautiful, especially in this climate, like alfresco areas. So people say the kitchen's the biggest selling point of the home. Like outdoor alfrescos is just it's WA. It's awesome. So
the builder was going to charge us a fortune to put it in, and it wasn't exactly what we wanted. So we got all the provisions put in. So we've got the hot and cold tap, and we've got the drain, and we've got the plug for the fridge. So we know what we want. It's just a matter of sorting it out.
Look, you've been amazing. Thank you so much for coming on. Like I said before, you've been amazing for me. I've had issues come up with clients or myself, whatever, and I go, hey, can I run this past you? And what's great about that, and obviously we're friends, but what's great about that is that you have that backing of Lavan that you've got. If you aren't the right person for it, you can put it on to other people. What's been great about you as well is that you've said, look, our firm doesn't do this. Here's a guy I recommend who's been amazing. So thank you so much for coming on.
Thanks
really appreciate it. Yeah, you're great. If people like this content and they think it's fantastic, which hopefully you do, please leave a review. Give us some feedback. Please like the podcast. Share it with your friends if you think it's relevant. But thank you so much for coming on, and we'll chat soon.